Yes, Mr. Street.
Yes, my lord. So I turn to ground 2, the Vires challenge, which is in my skeleton at 79 to 96. In my submission, there are 3 issues under this ground. The first is, did the Section 73 permission envisage that an approval of reserve matters granted on an application made with reference to the outline permission would be effective to grant reserve matters approval for the purposes of the Section 73 permission?
And so that's a question of construction.
That is a question of construction.
This particular Section 73.
Of this particular Section 73 in the circumstances of this case.
Yes.
The second is, did the approval granted by the local planning authority challenged in this case have the effect of granting such approval?
Then that's a question of construction of the decision.
Yes, my lord, agree. And the third is, was the grant of such an approval within the scope of the local authority's powers? And that's a question of statutory construction.
Yeah.
Now, I say, before I turn to deal with each of those in turn, that the essential premise of my learned friend's submissions is that the approval of reserve matters pursuant to the application made on the 23rd of May 2023 under the Outline Commission was incapable in law of discharging Condition 2 of the Section 73. That's the essence of what he says. And he says that because he says Condition 2 of the Section 73 requires an application to approve reserve matters to be made by a date which has passed, and therefore the Section 73 permission was really waste paper. He says on its face it required something in a non-severable condition which was impossible at the date of grant. And I reject that premise on the true construction of the Section 73, and that's what I turn to deal with first, the interpretation of that consent. That is dealt with in my skeleton at paragraphs 50.
Can you look at the consent as well? I know it's old-fashioned.
No, I have the reference here. It's page 26. I just wanted to give my lords the reference for where I deal with it in writing, which is paragraphs 37 to 38 of my skeleton. So it's tab 3 of the supplementary bundle. And my lord, before we look at the words, just by way of the context, as we know, this was granted on the 10th of December 2024, 20 months after the reserve matters application had been made on the 23rd of May 2023, and 15 months after the deadline for making an application for reserve matters approval had expired in September 2023. If we then turn to the description of development, it opens with the reference to variation of condition 13, attached to planning permission reference 1600151 AOP. That's the outline permission. I will come back to the meaning of the word variation there, but it is expressly a variation of condition 13 of the outline consent. That's what it intends to do.
Can you do that? I mean, I thought Lambeth said you couldn't vary. You had to.
You have to grant a new consent, but I want to show the court in due course what's said in Hillside about the use of the word variation in a permission. So it is used colloquially and indeed in decision-making documents to mean something which is slightly different from its legal effect in my submission. Then if we look at condition 2, condition 2 is framed as requiring an application for reserve matters shall be made no later than 18 months from the date of the outline permission. Now, that was a date in the past. The effect of that, I say, is that properly understood, what is meant is that the permission granted is for the development described in the outline permission in accordance with any reserve matters approved pursuant to an application made in respect of the outline permission within 18 months of the grant of outline consent, i.e., if there are valid applications for approval pursuant to the outline permission and those are approved, that will be effective to discharge condition 2, to grant approval.
Say again, what do you say condition 2 means?
It means that if there are valid but undetermined applications for approval under the outline consent, then the effect of approving those will be to approve reserved matters for the purposes of condition 2. And condition 1.
But the effect of approving those will be what for?
Will be to approve reserved matters for the purposes of this permission, for the purposes of section 73.
And that's the result of condition 2.
Yes. Because it cannot sensibly have meant, and I'll develop this, but it cannot sensibly have meant you must make a new application by a date in the past. That's not what's envisaged by this condition. What it means is if there's an application which has already been made and that is approved, that will be approved for the purposes of this permission. And I say that is the natural and ordinary meaning of the words used.
But we're not dealing with approval of reserved matters here. We're dealing with condition 13, aren't we? Which isn't a reserved matter.
But this condition was changed as well, my lord, condition 2, to refer to the date of the outline permission rather than this permission. So that there was a deliberate change made to the wording of condition 2.
But why did you need to do that if, in fact, condition 13 has got nothing to do with reserved matters?
Because otherwise, what would have been the approach to reserved matters under this permission? There would have been a deemed condition to like effect, and I'll come to that when I deal with the statutory consent, with the statutory scheme. Because of necessity, if you grant an outline section 73, it will be deemed to be subject to a condition which requires you to make any application before the expiry of the specified time limit in the original outline permission. So this is essentially putting into words what would have been deemed by operation of the statute. And were that not so, then the question would have been, well, what are the reserved matters to be approved? On what condition are reserved matters to be approved under this permission? This tells us that it's the applications made with reference...
Well, it might equally tell us you can't make any.
Well, in my submission, that is not the correct construction of the document, apart from anything else, because what would then be the point of granting the application?
Well, very good question.
And I mean, I will come to that, but I do say that this decision notice was not challenged and is not in my submission a nullity. It's not waste paper. It is capable of being given a proper construction, and the construction is the one for which I contend.
So the point is, because you wanted to have some change, condition 13, that's the only thing you wanted done was to take out the first paragraph. Obviously, that's only going to be relevant if the rest of it comes into force. So if things necessary for it to have come into force were done under a different planning permission, it must have been the intention that they were shipped across to the new planning permission.
That is my submission, yes.
Gosh.
And I say that that comes from the word variation, amongst other things in the description of development. And at this point, if we could turn up hillside.
I mean, condition 1, let me ask you, could condition 1 have said details of the appearance, landscaping, layout and scale shall be those approved by the local authority under planning permission 16001510P?
Yes.
That would have made it clear.
That would have been better drafting. My learned junior says only if they were approved. It could have been drafted either to envisage their approval or on the basis that they had been approved.
Yes,
but,
exactly.
But yeah, that would have been better drafting. I'm not disputing that. That isn't the way in which it was drafted, but that is, I say, essentially the effect of what was consented under the section 73. That was the intention of the corporate body that issued this document.
Well, they've got to be careful. They might have intended all kinds of things. The question is whether or not that's what the document means.
My submission is that is the objective reading of it. So when I say the intention, I mean the intention as understood from the words used in the document. And I wanted to turn up hillside, which deals with the meaning of the word variation when used in a planning consent. Hillside is tab 22 of the authorities, starting on page 462.
have the page reference?
So the page is 483 that I want to go to, starting at paragraph 74. And if I might just ask the court to read 74 through to 77.
Well, do we need to read 73 to understand 74?
Yes, my lord, that... Now, my lord, I accept this is dealing with full permissions, not outline consents. But the proposition which I draw from it is that the natural and ordinary understanding of the use of the word variation is that you are granting permission for that which was previously consented, subject to the amendment that you explain in the varied consent. And I do say that that is consistent with the way in which the Section 73 decision notice is framed, where the description is a variation of Condition 13. This issues a new permission, but what it intends to do is to grant a new permission subject to essentially one change, Condition 13. That previous permission was subject to a condition that reserve matters needed to be approved and hadn't yet been, as is this permission, and the approval on one will be the approval for both. That is my submission as to how this should be understood.
Would it work for applications made but not yet determined at the time of the Section 33 permission?
So that is what we have, the facts that we have in this case.
Yes. There's one thing to say they've approved it, and when they granted, they're looking back. But here, it's different. It's not something that they have yet approved. It's something that they will approve.
It's Schrodinger's approval. It may be approved.
It may be approved, yeah.
That is, as I submit, what this means. It's if approved. That is how I say this is to be understood. I also say that that is consonant with the statutory scheme. I'm not going to do it in detail, and I'll do that in a moment, but if I could just look at section 92 with the court at this point on page 10, tab 1 of the authorities.
They had approved the changes in Hillside, had they? They'd already been done at the time of the second permission.
So in Hillside, they were full permissions.
So there's no issue of reserve?
No. What I wanted to point to in the statutory scheme is that even where a condition is, so this is section 92.2, even where a condition is not imposed, the legislation deems a condition will be to the same effect as section 92 2A. And I also, my Lord, wanted to point to section 92, 3A and B.
How do you say section 92, 2A helps with your construction of the planning permission?
Because the planning permission is seeking to comply with this requirement by imposing a condition which doesn't interfere with this requirement, i.e. it doesn't say you cannot, it doesn't permit you to make another application. You have to rely on existing applications. But it also doesn't have the effect of extending time for making that application, because it's only relating to as-made applications. I also just wanted to draw attention.
So what you say we should, or the reasonable reader should infer from condition 2, is that there can't be any further applications, and therefore, insofar as there may have been applications already made within time, they can be referable to the section 73 application, or permission.
That's precisely what I said. It means yes. And I just wanted to point to the position in Wales under section 92. It's 3A and B on page 11. Because in Wales, the effect of the legislation is that there will necessarily be a deemed condition precisely in the terms imposed by condition 2, i.e. that an application for approval must be made not later than the date on or before which the previous permission required an application for approval. And that is what condition 2...
Sorry, where?
So it's 3 capital A and 3 capital B on page 11.
Oh, I see. 3 B, yeah. Yes.
So I say that is exactly what condition 2 does, and that cannot offend the legislation, because the legislation deems such conditions onto permissions in Wales whenever you have an outline section 73.
Many other things, if you read 73 and 92 together, they make sense in one way, because they're dealing with conditions attached to planning permissions. If you want to implement them, you've got to do so within the timescale. If you want to change them and put in different requirements for implementation, you must do all of that and leave enough time to make the Section 73 change and to comply with the reserved matters. And the problem here is there wasn't sufficient time. Because by the time you made the 73 application, unless you're right, you necessarily wouldn't be able to make any application for reserved matters.
Well, this really comes to the Section 31 point, but the implementation date hasn't run out. On my submission, runs out on the 4th of March this year. So they are still in time to implement.
No, I mean to make the application for reserved matters.
Yes, so...
The idea is that if you... what I'm saying is 73 and 92 run together. If you want to apply for reserved matters, you must do it within X number of years from the grant of outline planning permission. If you want to change something in the outline planning permission, but that change still requires approval of reserved matters, you must do both within a time scale which allows you both to change and get the 73 permission and to make the application for any reserved matters. It wasn't intended to allow you to get a change of the conditions many years afterwards and have a new planning permission and go back to other planning permissions.
You can get a Section 73 at any point, including after implementation. That's what Lambeth says. So there's no time limit on when you get your Section 73. The time limit is on when you make your application for approval. The application was, well, there were 2 applications, both made in time. It's then in the hands of the local planning authority, and it's for the local planning authority to determine those applications. It's not for the the making is in the hands of the developer. The determination is in the hands of my client, who are a democratically elected public authority acting in the public interest. They will determine them as soon as they reasonably practically can. They can agree extensions of time, but it's not gaming the system if the application is made in time to approve them at one point and to grant a Section 73 at another. And there's nothing in the legislation, I will come to this, there's nothing in the legislation that says you cannot make a Section 73 before you've approved the reserved matters. That's not what it says. And my point is that, in fact, if you look at 3A and B in Wales, it clearly envisages that there will be amendments to Section 73s with outstanding deadlines for the approval of reserved matters, and it deems a condition to deal with that in 3B, and that condition that it deems is the same as a condition in Condition 2 in this case. So I say it's totally consonant with the legislation. The final point that I make, and I do say, although I sense that I'm pushing uphill, that interpretation is clear on the face of the decision notice, but if I'm wrong about that, I do say that the validation principle is in play here. And the
What is this principle? You keep referring to it. I mean, until this case, I'd never heard that phrase used.
It's in the authorities bundle, page 457. It's the Court of Appeal decision in Symmetry, the judgment of my Lord Justice Lewison.
Well, then it must be right. I'm sorry. I could have been more respectful before I went into it.
I was junior counsel for the Secretary of State, who I think advanced the submission in that case.
Which page?
So it's 457 of the authorities. And I'll ask my lords to read 68 to 71.
What was going on in this case, though?
This was a case in which there was a condition on a planning permission which used the word highway, and the question was whether that condition had the effect of requiring the land to be dedicated as highway or not. And the High Court said that it did have that effect. That contravened a long-standing principle of planning law that you cannot require a highway to be dedicated by condition. And my Lord Justice Lewison overturned the High Court and said that, in fact, the meaning of the word highway in that case didn't mean public highway, it meant road, and that was upheld by the Supreme Court.
As they should.
We're looking at paragraph 68
to 71.
Oh, I see, yes. When you say that normally you try and make things valid as opposed to invalid, yes,
Yeah.
Okay.
And provided it's a realistic interpretation of the document, that which makes it valid is to be preferred. And my submission is it is certainly a realistic interpretation of the document, especially when read in the context of the statutory scheme, as I just explained.
There are other authorities, such as Fawcett, which say much the same thing, that if you've got a condition, you should not strive to make it incomprehensible.
Yes.
You should strive to try and give it some meaning and purpose.
It's not validity at all. There's nothing invalid about this permission. It's a question of trying to make it workable. And what you're really asking us to do is favour a reading of Condition 2, which makes it workable in the way that you want. It's nothing to do with invalidating. The planning permission is perfectly valid. Whether it achieves anything is another question. But what you want to do is say it's workable only if you do this.
Well, my submission is that it would be essentially a nullity if it required something to be done by a date long before the permission was granted, the date being apparent on the face of the document.
It's not a nullity. It doesn't make it invalid. It just means that having set certain things out, it's not going to achieve those things. But it's not a document that you couldn't get a declaration to say it's unlawful. It just doesn't achieve what it wants.
Well, my lord,
I don't think it matters because it's the same principle.
It is the same
principle.
principle.
Try and make it workable or valid.
Try to make it workable. I think you probably could, if it meant what my learned friend says it means, get a declaration to quash it, because it would be irrational to grant a consent in those terms. And for that, I rely upon Hill. Don't think we need to turn up, but it's authorities 103, paras 13 to 15 and 17. where the court said in terms that it would normally be unreasonable to grant planning permission which on its face made permit the permission incapable of implementation. My learned friend said, oh well, Hill in fact supports him because the court didn't quash in that case. The reason it didn't quash is because there was no substantial prejudice and therefore the claimant was not a person aggrieved. That arises from paragraph 17, because at best their case was they had a useless permission rather than no permission at all. So I do say Hill supports me.
If we go back for a moment to the section 73 permission,
Yes.
in the supplementary bundle, page 26, and we look at what it is that the planning authority are permitting, they are permitting the variation of a condition attached to planning permission with the numbers, outline application with all matters reserved, except access. I mean, do you say that that phraseology incorporates by reference what is in the outline planning permission, including the reference in that planning permission to the approval of reserved matters, such that the two permissions are tied together for that purpose?
Yes, and that's why I showed my Lord Hillside and the significance of the word variation. It's precisely because the word variation is the first word of the development permitted here. So that is, I say, the clear intent of the document. That is what it intends to do.
The question still remains what the council actually did, because one of the things you observed in passing earlier was that you were suggesting that it would enable the council to grant reserved matters for both permissions. I'm not sure that is what happened here, was it?
So that is the next issue, the effect of the decision notice. I will accept now, I don't think that's what the council thought it was doing. I think it thought it was only granting it under the section 73, but in my submission, the effect of the decision notice it issued was to grant it under both.
Well, how can it do that? Consistent with the statutory scheme, it seems to be very clearly identifying that one needs to be clear about what the permission is, what the which permission reserved matters are being submitted pursuant to, and therefore what they are being approved for, so that one has a very clear audit trail as a member of the public as to what is being granted and pursuant to which permission.
I will come to that with reference to the statutory scheme, but just in headline terms, firstly, Article 6 of the DMPO is in the singular, but of course the singular incorporates the plural unless the contrary intention appears. There is no reason why you could not have a reserved matters application which is made pursuant to two outline permissions, as provided it specifies both.
I'm going to say provided it specifies. You keep saying we can do this. We can do lots of things. The question is, what do you do? And in order to know what you've done, you look at what people say and do. So you've got to look at, otherwise it's convenience. No public person would be able to find out. So you've got to go back to the documents.
I agree, my lord, and that's why I said that I'm jumping ahead to the statutory scheme, because I would like to go to the decision notice first. But to answer my Lord Justice Dove's point, point one is that the scheme of Article 6 does not require it to be a single application. And point two is that even where there's no reference number in the application, provided the permission is sufficiently identifiable, the court has upheld that. Indeed, the House of Lords upheld that in Inverclyde. I will come back to all of that when I do the statutory scheme, but just to flag.
I've got questions, but I'll shut up.
So if I can then turn up the decision notice for the reserved matters approval, that is core bundle 29, page 444. And the description is above the word at and below the word scale 2.
It tells you what it's dealing with, first of all. It's subsequent to your application, and that was only an application under the OPP, wasn't it?
Yes, my lord, it was, and I was going to say the reference number is at the top, 230163 ADP, and that relates to the application made on the 24th of March 2022, for your note, page 21 of the supplemental bundle. It was made at a time when the Section 73 permission did not exist,
Yeah.
and therefore clearly it was made at the time with reference to the outline permission only. I accept that. The description is then varied to include both the outline permission, outline approval 16.00151 AOP, and then it says as varied by application 24.02780 VRC. And I say the effect of that was therefore to grant the application on the application made, but with the effect of approving reserved matters for the purposes of the Section 73 permission. And as far as my Lord Justice Dove is concerned about the audit trail is dealt with by the variation because it includes both of the reference numbers in the decision. So the question is it lawful to do that?
Well, hold on. So you're saying it does both. It grants the approval for the OPP and for...
Yes.
So how does the member of the public know when Mr. Mohammed's diggers turn up on site which permission he's implementing?
Well, that turns on the ordinary principles in line with commercial land, the extent to which you're complying with the permission and the conditions to which it's subject and the drawings.
It's quite important in relation to condition 13.
Well, theoretically, yes, although practically no, because in this case, it would not be rational for the local authority ever to take enforcement action against the first part of condition.
Well, that may be an answer to the whole of this case.
Well, I mean, I've got section 31 at the end, my lord.
But it's not an answer to my question.
But I can ask exactly the same question. Imagine that 2 full planning permissions are granted in those different terms. How does the member of the public know? And there can be no question before this court that you can grant 2 permissions in those different terms. That is just the effect of a Section 73.
Just looking at it, subject to your OPP application, what is being approved, hereby grant approval to the access, appearance, landscaping and scale to reserved matters being sought for appearance, landscaping, layout and scale for 153 dwellings, and discharge of condition 22 and condition 8 of outline approval 16 blah 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 as varied. But that variation doesn't affect reserved matters. Indeed, it's not even a variation in truth, it's a Section 73 planning permission. But those words wouldn't tell you anything. Why would you think that reserved matters for that also included reserved matters for a different approval, a different planning permission?
Because you have to read the documents together.
Which documents together?
This decision notice,
Yeah.
the outline permission and the Section 73. You have to read them together. This decision notice doesn't make sense without looking at the, quote, parent permissions, what it is approving. When you look at the OPP and the Section 73, you see the outline permission. You then see the Section 73, which, as my Lord Justice Lewison says, starts with the word variation. And then you see this consent, this approval, which clearly is an approval on an application made under the outline permission, but also refers to the variation permission.
But
and
the
that
variation doesn't affect the reserved matters at all. This is approval of reserved matters. If you're reading, you think, well, that's interesting. Outline approval as varied for condition 13, but condition 13 has got nothing to do with reserved matters. So it's very odd to say it's approving reserved matters. It's referring to a variation in another planning permission, which doesn't concern reserved matters. But nonetheless, the approval of the reserved matters on this application is also brought in as a second and additional approval for matters in that other planning permission to which reference has been made in a different context.
But if you were to go and look at that other planning permission, you would see, one, this needs an application for approval of reserved matters in order to be implementable, and 2, for the reasons I already gave, it envisages that those will be the reserved matters approved on the original outline consent. See the word variation and the way in which condition 2 is framed.
Why doesn't it just say reserved matters under this and also under planning permission, whatever?
Well,
that would make it clear, wouldn't it?
That would be better drafting, but the word variation...
It's not just better, it's necessary. As a member of the public, I need that to know that that's actually what you're doing, because at the moment, it doesn't actually tell me that. It's all that what you're describing is an elaborate construction, reconstruction planning history, which enables the answer that you wanted to give, but that's not what your clients were trying to do. The question, which my Lord Justice Lewis is pursuing, is how does the reasonable reader of this document arrive at the conclusion that actually not just one set of reserved matters has been approved, but in fact 2 sets have?
Because there are 2 outline permissions referred to, 16.00151 AOP and 24.02780 VLC.
If we're trying to understand what this document means, do we read it as a whole, or do we confine ourselves to the decision part of it?
As a whole.
Right, because in the informatives on page 451, paragraph 2, I notice, says this reserved matters permission is to be read alongside outline permission, blah blah, and permission, and that's the section 73 permission. So
yes.
That might be a better peg for you on which you can hang this particular argument than the description of what is actually approved.
My lord is right, and that reinforces the submission I was making. I mean, the word "and" is as my Lord Justice Dove was putting to me, it should have been drafted.
You mean that's very read alongside? What I mean, wouldn't the informative be this reserved matters permission is granted under, not to be read alongside. Read alongside means it's a separate document that you read it with, and you need to read it with because for some reason there's been a reference to an immaterial variation in the second paragraph. That's why you read it alongside. You have to understand what the condition 13 is, not what this is granting. It would have said something quite different. This reserved matters permission is granted for both.
Well, I mean, my submission will not improve with repetition, but it is that it's a hereby grant approval for, and then we have a reference to both, and to the extent that there's ambiguity in that is resolved by the informative.
Because there's not too much of a problem if we don't go down that route in practical terms, because all that it means is that the first permission is in play, but you've got to comply with 13.1 and get your programme of waterworks, and your section 73 permission exists, but it needs further tweaking in order to achieve it. And we would be deciding to read this in a particular way to achieve something that could be done in another way.
I don't dispute it could be done in another way. That is a section 31 point. Ultimately, and this is the consequences point that my Lord Justice Lewis put to me previously.
Well, it is. It goes. It's a virus point. What my Lord Justice Lewis is putting to you is that you did have power to do what you did, just didn't do what you wanted to do. You had perfectly reasonable power to grant the reserved matters under the original outline permission. That's what you did. And so the whole point falls away. It doesn't need section 31 at all.
Yes, my Lord.
Just the law of unintended consequences applies.
Well, I mean, to an extent, the section 73 permission is not challenged and is not before this court, and it may well be for another court to decide whether, if the reserved matters approval is upheld, the section 73 permission can be relied upon in those circumstances. But I just flag, as I did earlier, that no reasonable planning authority could ever take enforcement action against breach of a condition which it has agreed is not necessary in a section 73 permission.
But all we are concerned with, is this right, is the validity or otherwise of the decision at page 444 of the court bundle.
Yes, my Lord.
If it's valid, even if it only relates to the outline permission, then the appeal fails, and the consequences of that may be that the developer has to satisfy the whole of condition 13 at some future date, or it may not.
Emphasis on the may, yes. I agree. So I think where I'm getting to is I don't need to go as far as I do.
You're trying to prove too much.
I don't think I need to go as far as I do. For the avoidance of doubt, I maintain that my construction of the consent is the correct one, but I don't need to prove that to succeed in this appeal. I turn then to the scope of the powers under the 1990 Act. My essential submission is that a local planning authority does have the power to grant a section 73 permission, which envisages reserved matters may be approved pursuant to an outstanding application for approval of reserved matters made in time in respect of parent permission. Now, it may be that that's not what was done in this case. My lords may be against me on that. But I say as a matter of principle, that power exists. And I say that because it is consistent with the language and purpose of the 1990 Act, because it is consistent with such authority as there is, and because it avoids absurdity. I take them in turn.
Speak for myself, I don't have any difficulty with that as a legal proposition. I mean, suppose that the reserved matters under the outline permission had been approved by the time you come to make the Section 73 application. I can't see any reason why the planning authority shouldn't say either we discharge the condition about approval of reserved matters completely, and we just say the development shall be built in accordance with plans, whatever they are. And I don't see why the local planning authority shouldn't modify a condition to say the development will be constructed in accordance with such plans as may be approved under planning permission such and such. So I don't, as a legal proposition, I don't have a problem with that. The question is what happened?
Is that what happened? Well, my lord, my learned friend does have a problem with that proposition. I'm in the court's hands as to how much it would assist the court for me to develop it.
Not sure that he does have a problem with that, legal problem. He says you can't switch one application to another, an application under one permission to another permission, but that would depend on what that other permission required.
Yes, my lord. I mean, my understanding was that he did have an issue with that, but perhaps he could confirm, and then I know whether I need to develop.
Well, I think what he was saying was that the Section 73 permission included Condition 2, which required a separate application to be made for approval of reserved matters under the Section 73 permission, and you couldn't treat the application made under the outline permission as being substituted proxy for the application which the Section 73 permission required to be made. But if it didn't require an application to be made and it said we've approved these drawings, you just carry on with those drawings, because that's what he was getting out of PowerJet. He was distinguishing between plans that had already been approved on the one hand and plans to be approved on the other. I didn't understand him to say that you could not draft a Section 73 permission which envisaged that the development would be constructed with according to plans yet to be approved under different permissions. I may have misunderstood the submission.
But that is correct.
Well, then, my lord, I think we're ad idem on the law. And I think that must be right because of the word making being the statutory focus. Were approval the statutory focus, that might be different, but the whole point is that it's the making, which is the vice against which the statute is directed. And I won't do any more than this. I'll just say for my lord's note that in Whitley, which is the case I asked to be added at page 670, Lord Justice Wolfe is very clear that the concept of making involves Parliament understanding that developers may make applications and local planning authorities may sit on them for a while. My lord, in those circumstances, I think I can turn simply to section 31(2)(a). And my submission is that if I'm wrong on the correct interpretation of the permission, the position is nevertheless that relief should be refused under section 31. The principles, I think, are well understood. They come from Bradbury, the judgment of my Lord Justice Lewis, paragraphs 70 to 71, authorities 606 to 607, which makes clear that the assessment is of the impact of the error on the substance of the decision taken. And Gathercole, a judgment of Lord Justice Coulson.
You need to talk it through as it was done in Bradbury. You need to identify the substance of the decision, the error that's been made, and why it's highly likely that that decision which you've identified will not be substantially different. So we're looking at the decision at 444, are we?
Yes.
And and what's the error that's been made?
Well, I think that the error that my learned friend relies on is the inclusion of the words "as a variation of."
That's irrelevant. You know.
So if that's an error, my submission is that it's highly likely the outcome wouldn't have been substantially different because you'd still have had an approval in the same terms.
Section 31 doesn't really go to what is the key issue. What does this decision do? If it does grant permission only for OPP, then Section 31 is irrelevant. If it does grant permission for Section 73 as well as or instead of OPP, Section 31 is irrelevant. It's a wonderful judgment, but it just doesn't apply.
Well, the one thing I would say is I think where it does come in is the point that I was making under ground 1, if I'm wrong on the construction of condition 13, if there was a breach of condition 13. And that was the point that I developed earlier, that in circumstances where there's been a section 73, we know that any breach of condition 13 wouldn't make a difference because the local authority has already taken the view that compliance with that part of the condition is unnecessary. And the purpose of section 73 is to provide relief from breaching the condition. So that, I think, is the slim ambit of Section 31's application in this case. Yeah. My lords, those are my submissions, unless I can be of further assistance.
Thank you very much, Mr. Street. Yes, Mr. Howard.
My lords, in the interest of time, I will try not to repeat too much of what has been said in relation to legal authorities that are quite settled. Can I just
take in the interest of time, Mr. Mohammed, you won't repeat any of it.
I'm grateful. Can I take it thematically first instead of another way and try and help to fill in some gaps in relation to what you have heard? The first is this compliance table that you will have heard a great deal about.
Yes.
I think it's useful to just give you the full context of what this document is about, because it does go to a key ground of the appellant here. This you will find in the supplementary bundle, page 194.
Yeah.
The context of this document is that, first of all, it's a matter of fact that it wasn't actually part of the pleadings of the appellant. It was introduced on the eve of the hearing before Mrs. Justice Lang in order to bolster the case put forward in relation to the discharge of condition 13. And in terms of the points that my learned friend, Mr. Streeton, had pointed out to you today, I just thought I'd add a bit more flesh on the bones. This is a document that is actually an internal document of the IP1 to try and track what they are trying to do in terms of this development, where the application had gone in 2016, first permission granted in 2020, legal challenge, and today we sit and stand here in 2026. And this was an internal talk of them trying to understand what do we have to do in order to move things along. And they had shared this with the council, not as part of the application to discharge any of these conditions, but to kind of say to them, we are doing work through the background, we are trying to move as quickly as possible, partly because of the inordinate amount of legal challenges that have been coming their way at every single stage, some of which involved my learned friend for the appellants.
Is there any evidence about this?
Exactly.
This was said before, this was put before Mrs. Justice Lang. This is what was said.
No evidence is a witness statement.
Is there some evidence about it?
There were submissions made explaining this document before Mrs. Justice Lang, and I can take you to the particular passages, but the points that were made were accepted by her to try and understand what this document was there to achieve. And the coding system is what my learned friend and I who had also mentioned, was just an idea of a categorization of the conditions rather than saying we are complying with them or they are not being complied with. That's what we had submitted before Mrs. Justice Lang in order to assist.
It's a bit unsatisfactory not to have any evidence about this at all.
I imagine that was because it was produced shortly before
The night before.
Before the hearing.
The night
there
before.
was no opportunity to
Whoever
respond
put
to
it in would have to, in judicial review, you can't just produce anything. There are books on this telling you what you've got to do. And there's judgments of people like Lord Justice Singh who say you can't just produce a document out of thin air. You've got to have a statement.
I'm with you, my lord, but this was ambushed on us the night before the actual hearing.
Well, your submission should be we can't possibly refer to this because we have no evidence as to what it is.
I'm grateful for that indication. I'm grateful for that indication. The highest, I will say to you, 2 points that I'll make, and then I'll move on from this. The first point to make to you is that this is not a council document, and that's a matter of fact. They weren't going to use this to decide how to make a decision. That's the first very simple point. And this is a document that was there as part of the interested parties' internal conversations about this use. That's it. That's the best I can do in terms of...
It's not an unusual kind of document
No.
in a permission like this with multiplicity of conditions and a responsibility on the local authority to, I'm going to say police them, but you know what I mean.
Yes, I'm grateful. I'll leave it at that, my lord. In terms of the next point in relation to the discussions that were had about the Section 73 and the relationship with the reserve matters and what was being decided pursuant to what, can I just make a few observations on this? And for this, I think it might be worth turning up the judgment below in terms of how this was actually looked at page 205. At page 205, you'll see, this is Justice Lang considering this issue of the effect of the permission under Section 73. You can see that heading on page 205. My lords, and you can see there, she sets out what it says, what the legal principles are, and then when you get to paragraph 132 on page 209, you can see what she is grappling with as part of the submissions that were made before her. I would just make the observations in relation to this as follows. You have the outline planning permission that was granted originally. You then have the reserve matters application. That is yet to be determined. You then have the Section 73 application that is granted, unchallenged by the claimant or any other party. And what then happens is, for the purposes of trying to be administratively careful about what and how the Section 73 application relates to the reserve matters application, the interested party writes to the council and says, we would like to vary the description of development in order to make sure that the Section 73 has a relationship with the reserve matters as granted. And this is what Mrs. Justice Lang is addressing in these passages. And at paragraph 142, her conclusion substantively deals with this point in relation to whether or not ultimately this point goes anywhere. In terms of what the council's documents then record as a matter of fact, there are three documents that are just worth looking at. In terms of the first document, at supplemental bundle page 26, the one that my learned friend had been taking you to in relation to this point.
SP 26, did you say?
Page 26 of the supplemental bundle.
Yeah. No, the Section 73.
This is the Section 73 application. And again, the when the Section 73 application was granted, all it did was vary one half of condition 13, and then it subsequently just reprints the rest of the permission, as it were, because there were no other changes in relation to the other conditions.
Apart from condition 2.
Apart from condition 2. And so what we are dealing with here, as far as what the appellants are doing, is effectively a collateral challenge to the Section 73 application. They were ultimately missing the opportunity to challenge. They seek to challenge it through the challenge of the reserved matters application. And that's what we had put before.
I don't
the
quite
learned
follow
judge.
that. Firstly, I don't understand it, and secondly, I don't see why it's relevant. I mean, at the end of the day, this turns on what the decision was, and if it means one thing, is it valid?
I take the point, and what I think, Lord Justice Lewison, I think the point that you had made, which I agree with, is in relation to whether or not this was the reserved matters was made pursuant to the original planning application. If that's right, then your point about us being in breach of condition 13 is a matter for the council to decide as to whether or not they enforce or not.
Why are you in breach of condition 13?
In circumstances where there is the variation that we are dealing with in condition 13, if the reserved matters, as it was, had contained the full condition 13 pursuant to the original planning.
Query, are they reserved matters? That's the construction argument.
Correct.
Now, assume for the sake of argument that Section 13 is not anything to do with reserved matters.
Condition
13. And assume again for the sake of argument that the only time requirement of condition 13 is that it be
outside the section
outside
92.
Outside condition 2 is that to be satisfied before development begins. Assume those two things.
Yes.
We
would not be in breach.
There would be no breach.
Would there be no breach? There would be no breach.
You would be in breach if the bulldozers turned
Correct.
up. But they haven't yet.
Correct.
Which is where the observation about which planning permission are you implementing becomes quite important. Because if you're implementing one planning permission, you don't need to discharge that before you turn up with your diggers. But if you're implementing the other one, you do. And as a member of the public, I might like to know that.
I can't speak for what the council's view was on this point, but I agree with my Lord Justice Lewison's point in relation to the outline. Condition 13 was not a reserve matter.
All we're concerned with, as I understand it, is whether the decision recorded in the decision notice at page 444 was or wasn't valid. Now, the judge seems to have gone on to decide whether it operated as a decision under the Section 73 planning permission, either as well as or in addition to the outline permission. But that's not the issue, is it?
I beg your pardon, I'm just trying to understand the question.
The issue is this decision notice a valid decision notice? Whether it's given under the OPP or under Section 73. And as it seems to me, it would be open for this court to say it was a valid notice under the OPP.
It would be valid it would be open for the court to say.
And then you either would or wouldn't have to satisfy condition 13, depending on the effect of either this Section 73 application or some future one.
I don't need to trouble that construction for my purposes.
Right. I mean, very wise judges have very often said if something is not necessary to decide, it's necessary not to decide it.
I agree. I agree, and I am content with that construction being a very clear construction that assists my client very clearly. So I beg your pardon.
Can I just check then, so I know that where you're going? Mr. Wells says you haven't got any valid planning permission to implement at the moment. Mr. Streeton says you've got two. Have you got one? Or have you got two? Do you have an OPP under Section 73? Or do you just have an OPP? Or do you just have a Section 73?
First of all, I'll agree with Lord Justice Lewison that I don't necessarily think the court needs to decide that depending on which way it thinks. But from my perspective, just to assist the court in terms of how we understood what was happening, is we had our outline planning permission on which we applied for our reserve matters. We were very keen to progress the reserve matters and get to a point where we could implement that reserve matters. But one of the things we needed to do was vary this particular condition, which we never accepted was a reserve matters issue. We then apply for the Section 73 application in order to be able to do that whilst the reserve matters is pending. There's no dispute as to whether or not the Section 73 was made in time. And then what had happened was the council had taken legal advice, and we were of the view that in order to ensure that the Section 73 was implementable and valid, it was important to add this particular change. Where we find ourselves now, if you were to press me upon this, I would have thought that we had a valid outline planning permission and a Section 73 that just tweaks that condition 13.
So have you got one or two planning permissions which you can implement tomorrow morning?
We have, on the papers and on the way that the judge understood it and the way that the council has advanced their case, we would have two planning permissions. But I would say that for the purposes of what we are trying to achieve, an outline planning permission pursuant to which the reserve matters were granted and pursuant to which condition 13 is not a reserve matter that we need to deal with as far as this is concerned, that is also open for us to do, and that's open for the court to decide and reach that
Sorry,
conclusion.
does that entail treating the decision as having approved reserve matters for both permissions?
The decision notice as contained in 444?
Yes.
Well, it does make clear in its decision, 444, if we just look at a few of the passages, having a look at it.
I mean, obviously, ideally, from your client's perspective, what you want is a planning permission where you can send the bulldozers in tomorrow without having to worry about the first part of condition 13.
Yes. If we look at what it says under reserve matters being sought for appearance, landscaping and layout, it does make reference to the outline approval with that reference, and then it says as varied.
But we know it doesn't do that. We know you've got two planning permissions. We had a Supreme Court case that said that. So you can't really avoid the question as to whether or not you have been granted approval of reserve matters for application AO 1600-151 AOP and also 02780 VRC. Are each of those a planning permission with reserve matters approved? Or if not, which one?
Our understanding of this decision notice has always been that the reserve matters were seeking to bring into a permission as varied with the Section 73.
In other words, I think to be perhaps over legalistic, you're saying that the approval of reserve matters operated under both permissions.
Yes.
So that both permissions have approved reserve matters, and the only difference between the two permissions with approved reserve matters is the omission of the first part of condition 13 from the Section 73 permission.
Correct.
So you are saying that this decision notice does double duty as approving reserved matters for both permissions.
Both planning permissions or the reserve matters application?
Both planning permissions.
For our perspective, from the way that we have advanced the case, we have always viewed that the Section 73 decision, the decision notice for the reserve matters that you're dealing with was pursuant to this, trying to bring in line with the Section 73 application.
So your client's intention
Yes.
or your assumption is that you have reserved matters pursuant to the Section 73 application, but not the outline planning permission.
That was our understanding of the decision
Yes.
that was being
So
challenged.
you have, to answer my Lord Justice Lewis's point,
It's the first
you
one.
have one,
Yeah.
but not
So-
two.
The reader of this will reasonably understand that although one council says nil, the other says two, and you say one, that it's obvious which it is.
That's why we're here.
And that's why I guess we are here.
They'll know eventually, I hope. So we can't decide which is valid, whether it's valid until we know what it does.
Yes, because I mean, the difficulty I have, which I think is worth also just taking up in the supplementary bundle, page 249. This is a letter that featured heavy in the first instance that my learned friend doesn't.
259.
249.
249.
I'll give the Constitution time to read this, but it's just the last main paragraph that deals with where it says on reflection.
Yes. So this is proposing the variation.
The variation. And that was our understanding at the time of what was being done by the council. Can I address the court on a few other factors in relation to ground 1A and the substantial alteration point? Just some basic points that I think are worth making in relation to assist the court in relation to this. So one of the things that one half of one condition that is not a reserve matters being varied, and whichever way the court looks at this as to whether there's no permission, one permission, or two permissions, we say based on both the Inverclyde line of authorities and Holborn Studios authorities, there is no way in which the appellants can make out that there has been a substantial alteration. There was never any attempt to remove condition 13 from the scope as far as the original permission was concerned. It's important, I don't think it's been mentioned, but as part of we agree with my learned friend here in relation to condition 13 is not within the section 92 timetable in terms of the timeline of the 18 months as submitted by my learned friend. We don't disagree with that. A couple of final points in relation to the context. If, for example, my learned friend, the point he makes about this section 73 application, if there was a different context in which we were seeking to vary a condition that could be properly be said to be a reserve matters application condition, then we would understand why there might be some concern about the fact that we are circumventing 92.5, or then we might be trying to have our cake and eat it, or whichever way that one looks at this. And final point on the scope question, I've addressed you on the compliance table, I've addressed you on the extent to which you can rely on that. I don't need to say any more. On the point of a final point on the my learned friend Mr. Streeton has addressed you on the point in relation to the argument over as varied, as I've taken you to in relation to that. Well, it's common ground that the Section 73 application, again, as we've dealt with for the same development with varied conditions, and the original planning permission remains extant. What we've always been struggling to understand in relation to the appellant's case is, as Mrs. Justice Lang had addressed, what is, apart from the legalistic point about the extension of time via the back door, what is fundamentally, if the court were to step back, what is the fundamental prejudice that's concerned here? What we have is a condition that's been varied, but its full force remains because we will not be able to occupy until those scope of works are done later on. Anglian Water did not seek to refuse to consent to that. They did not object to that. And that, we say, is also a very critical point for you to consider as far as any prejudice is concerned for WildFish. Final point is that when the Anglian Water were consulted on this point, one of the things that they talked about was that provided the preoccupation aspect of the works and the programme of works to come forward was maintained, they did not see any reason why this particular half of a condition could be removed. And again, WildFish, who had been consulted on this point, did not also say at that point that they had any particular concerns. My Lord, the only last thing I had was in relation to the section 56 point that we had submitted before the court. Do you wish me to address you on that?
Well, it doesn't apply, does it?
Well,
Or does it?
it doesn't apply insofar as this case is concerned, as my learned friend has pointed, but we were just going to make a few submissions on it in terms of what it means for the purposes of what you have to decide, because today is the day that this particular provision comes into effect.
Yeah, well, I think, please confine yourself to what we need to know about it for the purpose of what we have to decide.
Yes, well, it's in the context of Parliament extending time for the purposes of, previously you had it for the purposes of outline planning permission, and now it's been brought in line with the reserved matters. It's a quirk of fate that our case does not benefit from these provisions because of the timing of it, but what we were trying to bring to the court's attention is that this is a case that's been going on for over a decade and not a single house has been built, and we're now at risk of our permission being timed out at the beginning of March because of the ongoing legal challenges. And this is precisely a provision that would have allowed us to extend time but for when the permission was granted. And so we only bring it to your attention as a serious attempt by government to try and find as many different ways to ensure that legal challenges do not delay houses and permissions that exist. We don't directly benefit from that, but I just thought I'd bring it to your attention as a matter of just rotten luck that we find ourselves that we don't, and it's specifically related to bringing it in line with the reserved matters, which is what you're dealing with here.
Yes. If it comes in today, would it apply to any period over which we reserve judgment?
Well, there is an argument about whether or not the word permission, because it talks about when permission is granted, query whether the word permission means until your judgment or whether it means when you actually got permission. I think it would make more sense that permission means...
Well, Oh, I see, because it's a fixed extension of 1 year.
Exactly. So the question is whether if we got permission, if there was a permission to appeal, for example, tomorrow, we would have benefited, but because...
I understand.
So that's the point that I was just trying to...
Yeah.
You're right, in terms of where... So that's what we would say in relation to...
On your prejudice point, you said the government, I think you meant Parliament.
Parliament, I beg your pardon.
Was lots of houses built all over the land, and we mustn't get in the way of those figures. If it is an OPP that you've got, and you've sadly only got one reserve matters approved for the OPP, and you've got to do the programme, what date must you comply with condition 13 in order to build your houses in Buckinghamshire? You've still got time to do it, haven't you?
Well, yes, we do have time. If that's the court's decision, and we do have a valid reserve matters pursuant to the original planning permission.
So we're not frustrating the actions of Parliament?
Well, no, you wouldn't be. I'm
I
grateful.
didn't want to do that accidentally.
I'm grateful for you.
Although in truth, most of the time that's been spent in pursuing your development has been as a consequence of pursuing iterative amendments to your application for reserved matters.
Not as if you look at, my lord, the actual chronology in this case, which is contained at page 144, you will see the extent every single time there is an iteration or more information that's provided, it is usually because of a very significant and well-organized community who have come forward to challenge decisions, bringing forward points that we then have to respond on behalf of the council. So many of the iterations that you see, which is quite properly the normal way that you would expect planning permissions to work, I would suggest to you that a great deal of that, notwithstanding the 2 legal challenges now until the Court of Appeal, are due to the feedback that we have been seeking to respond from the local community in one shape or form.
I mean, it seemed to be suggested that it was something to do with the challenge process that was a problem here. But in reality, the challenge has been dealt with relatively promptly, even as far as here.
There is no question whatsoever that the courts in both legal challenges have acted swiftly, not least in the Court of Appeal here, where we have been granted the opportunity to expedite proceedings for us to be before you today. So there is absolutely no indication from us that this is a problem that has been delayed by the courts. Not at all. It's the process that's being used and the timing.
Perhaps Parliament might direct its attention elsewhere.
I'm grateful, my lords. If I can be of any further assistance, those are our points.
Thank you very much. Do you wish to reply, Mr. Welch?
Yes, I do, on just a few short points. I think on that last point, my lords will have seen the chronology, and my Lord Justice Dove has already, I think, drawn the right conclusion from looking at the very limited fraction of the time that's been spent on the actual judicial review proceedings, but I don't feel I need to say any more about that. Similarly, I will touch very lightly on the conditions compliance table, which I don't think, again, we really need to discuss, except insofar as it was put in on an agreed basis the week before the hearing, but there's no need to pursue that point any further. But I do feel I need to see that. I say that. I just want to address really 2 issues. One is the construction issue, and the second is a few further remarks on the Vireys issue underground too, that just arise from the discussion that my lords have had with my friends.
Sorry, what was the second point?
The Vireys issue underground
issue.
too. In summary, the construction of the decision notice is clearly something self-evidently of a muddle, if I may put it colloquially. The issue, as my lords have correctly identified, is whether, first and foremost, whether that is valid, and that decision notice is valid. And as my Lord Justice Lewison said, it is open for the court to say it was valid. If that's valid under the outline planning permission, if that is so, then the breach of, and one turns to the question of the breach of condition 13 and what the implications of that are. And I would say on that one has to ask oneself, was a breach of condition 13 something that was grappled with when the reserved matters application was determined? The answer is no, because that's.
You haven't got a judicial review on that ground, and you're now in the Court of Appeal.
No, indeed.
That's very interesting, but it doesn't help, does it?
But I think it does go to the issue of relief relief in respect of this as to.
If it's valid, then you don't get any relief. You normally get relief when it's invalid.
Yeah, that's right. No, that's of course right. I would highlight that the respondent's case, particularly the first respondent's case, has changed between the skeleton argument and today, which has made it something rather difficult to shoot at. And I think the position now is that it says there are 2 implementable planning permissions, effectively. That is, that there are the decision notice purported to grant reserved matters for both, and that is directly contrary to what the respondent said at 39 and 95.7 of its skeleton argument before the Court of Appeal. And I'm not just making these points as jury points. They are obviously relevant to the prima facie question of, is this a clear and correct interpretation or construction of the permission? And I do think those are actually quite powerful points telling against that. And it is now said the decision was to discharge under both. But as I said, in writing, up until today, the position was that it was just under Section 73, and you'll see there was no respondent's notice at that point against Mrs. Justice Lang's judgment. I mean, it's before my lord, so I'm not going to take a point on that, but it is relevant. So can the reasonable reader take my own friend Mr. Streeton's interpretation as the correct one? No, they cannot, frankly. given the muddle that the decision notice presents the reader with, and the strained interpretation that my learned friend has had to advance to try and get to the result he wants to achieve. And this, I do accept that the validity question, and as my Lord Justice Lewis has put a few times, well, what did the council actually do? That is, of course, the first question, but it does rather, it leads into the policy considerations that underlie the Viries question as to whether there should be a provision.
I think that's a mistake I made in Lambeth. I said I can understand what the council wanted to do, but did they actually do it?
Did they actually do it?
The Supreme Court said, don't worry about that.
I mean, in this case, the fact that such a muddle has been made from a decision notice that has purported to use this device, and I tried to use that non-pejoratively, does rather indicate that there's a problem here that Parliament has not specifically addressed, and there's no good reason to create this back channel for. My learned friend's submission is that a reasonable reading of Condition 2 under Section 73 is that it prospectively incorporates details not yet approved. And I say that is simply impossible. There's no principled basis on which a decision can be made to rubber stamp future details that have not been approved yet on another plan.
So you say that's a legal impossibility, do you?
Well, I just say there's no principled basis for that to take place.
What would prevent a local planning authority considering an application under Section 73 after an application has been made for approval of reserved matters under a different permission? What would prevent them from saying, we give permission, details of landscaping, etc., are to be those, if any, approved under some different permission?
Well, it makes a mockery of the need for there to be an application in respect of the particular permission that the developer wants to move
Why
forward.
should there be?
Why should there be an application?
I think you accept, based on PowerGen, that if they had actually approved plans,
Yes.
then the new 73 permission could say build in accordance with those plans.
Yeah.
I
I accept that.
The
The point is when we're in this middle situation before the details have been approved, the idea that one can go back to redraw the parameters whilst the local planning authority is still considering the details under the original permission creates a muddled situation such as we found ourselves in. And that answers my own friend's points on this.
There are the two potential scenarios on Mr. Streeton's submission that need to be teased out. One is his winner-takes-all scenario, that his decision notice or his client's decision notice grants reserve matters twice over. It does double duty, to quote my Lord Justice Lewison. That, you say, the decision notice is a construction that the decision notice can't bear, and in any event is inconsistent with the statutory scheme. But then the second question is the question raised by my Lord Justice Lewison, which is, isn't this just a question of sequencing? If the audit trail is clear, these are reserve matters, this is the parent permission, does it matter that those reserve matters have been applied for before you have granted Section 73 consent?
If you're in a position where the time limit has not yet expired, that's clearly a permissible route.
Why does the expiry of the time difference, this time limit, forgive me, make the difference?
Because it fixes, that's the end of the point at which you can make an application under the outline planning.
But I mean, if instead of granting the Section 73 permission when they did, the council had noted the application under Section 73, waited until they had approved the reserve matters under the outline permission, and then said, we discharge condition 13, and instead of approval of reserve matters build in accordance with the plans we have approved under the outline permission, you would have no complaint at all, would you?
No, that's correct, but that presupposes that it was possible to discharge the reserve matters at that prior stage. One can't jump. What my friend suggests is that one can jump straight to the second stage by using the Section 73.
In effect, they've acceded to the Section 73 application a bit too early.
Yes, and it creates practical problems, as we see in this case.
It's the same issue. It's whether these houses on that site have got the right appearance, layout and landscaping. There's no substantive difference between the reserve matters under the one or the other. So in terms of, does this meet the public aim? Does it look good? Is it well built and well laid out? The timing's irrelevant to that issue, isn't it?
Well, it's not irrelevant as a matter of principle, because the outline planning permission the principle of development is established contingent on the conditions, including the time limit condition, and that's the time within which the developer needs to make.
And the time limit condition is that you must apply for approval of reserve matters within 18 months, I think it was, but they could be approved years hence. But that happened here. That was all right. Yep. The same reserve matters, an application for approval of those reserve matters, and a decision. And the question is whether you attribute it, and you could have waited, as my law says. So what's the problem with saying, well, they didn't wait? I mean, what is so horribly wrong about it is what I'm trying to work out in planning terms.
It is about the parameters within which the developer is obliged to make their application under the outline planning permission. And in this case, I think on the facts, I accept that it is not probably at the gravest end of the scale of where this device would cause problems. There are other cases where one can well envisage it being worse. But it is about the parameters within which the reserve matters application must be made. And the point is, we're not just talking about new details being submitted after the deadline for reserve matters, but about the rules of the game for that application being changed after the deadlines come and gone. If the parameters are changed, that is tantamount to making a new application, which in this case couldn't have been made because of the rider to condition 2. If you want to make a new application, you need to make a new application, which in this case would have been within time, given that the details hadn't been discharged at that point. If the details are discharged, all the details discharged later down the line, there's nothing to stop a Section 73 going in and amending those later down the line. But that wouldn't cause the same principal problem.
So the sin against the Holy Ghost that's been committed here was the timing point.
That is right. That is right. Yes, and I think ultimately where this all goes is if in substance this was all acceptable, this does not create absurdity or problems, because the answer is to make a new application for planning permission.
Or to wait. Item 1, approval of reserved application. Item 2, approval of the Section 73 permission by reference to the decision on item 1.
Yep. And that aligns with the conclusion reached in Hillside by the Supreme Court.
Yeah.
But the fact remains a new application can be made. I don't have anything further to add by way of reply unless I can be of assistance.
No.
I'm very grateful.
Thank you very much. Well, there's plenty to think about, so we will reserve our decision. We're aware of the time constraints on the Commission, so we will endeavour to get our draft judgments out as soon as we can. They will come under a strict embargo, which means what it says, so they can be distributed only to those on the distribution list. The receipt of the draft will be your opportunity to correct our English, but not our reasoning, and not to introduce new points. We would hope that in the light of the drafts you will be able to agree an order disposing of the appeal. If you can't agree the form of order, please make short written submissions and we will make the form of order that we consider to be appropriate. The eventual hand down of the judgment will be electronically by email distribution to those on the distribution list and public release to the National Archives. Thank you all very much.